Please state your appearances.
Amanda Folger for the state.
Good morning, Your Honor. Attorney Aaron Schenk on behalf of Erik Metzig.
See you state in compliance with victim rights.
We are.
It seems that several of the victims' family members are present today. We are scheduled today for a sentencing hearing. I have reviewed the pre-sentence investigation, which is document 97. Is there any modifications or corrections to that document from the state's perspective?
Yes. On page 32, the sources of information of the PSI writer reviewed, it was written that they reviewed Oshkosh Police Department records. That should read Winnebago County Sheriff's Office records. And then on page 7, the start of the victim's statement, I would just alert the court that the victims have filed more recent victim impact statements in which they no longer support eligibility for extended supervision. Thank you.
Okay. And I have reviewed those as well. Any corrections or modifications from defense perspective?
No, thank you.
Is there any reason from either party not to proceed with sentencing today?
No.
No.
Then we will proceed. I will hear first from the state. Then after the state makes its recommendation, if any of the victim's family wish to make a statement, they certainly may. And the last word will be given to defense. Attorney Folger, go ahead.
Thank you. Your Honor, Erik Metzig stands before this court convicted of 2 Class A felonies for first-degree intentional homicide in the murders of his parents, David and Jan Metzig. David was 72 and Jan was 71 years old. Each of these charges requires life imprisonment. The only area for discretion for this court is whether to make Mr. Metzig eligible for release to extended supervision, and if so, at what point in time. Statutorily, the court may not allow eligibility for extended supervision before 20 years of imprisonment. A plea agreement was reached in this case back in August of 2024, in which Mr. Metzig agreed to plead to both charges in exchange for the state recommending that the sentences run concurrent and that the court find him eligible for extended supervision after 50 years. A PSI was written back in October of 2024 recommending life with no possibility of parole, and the victims have submitted their impact statements with their own similar recommendations. The state recognizes that Erik Metzig has no prior criminal history. He was 25 years old at the time of the homicides and is presently 28 years old. He was previously treated for depression and anxiety. He holds a bachelor's degree from UW-Madison for computer science. That's about where the positive or mitigating factors end, though. There's no question that Mr. Metzig committed each of these homicides. The evidence in the case is extremely strong. On March 18th of 2023, law enforcement was dispatched to the family home after a 911 hang-up. When deputies failed to make contact with anyone at the house, they called Jonathan Metzig, Erik's brother. Jonathan came back home and went inside, looking for his parents. He was the first person to find them in their bedroom, each shot multiple times, covered in blankets and with their heads wrapped in plastic bags. Law enforcement searched the residence and located a journal in Erik Metzig's room. Numerous entries were made, but of significance, the following written statements were found in this journal. Quote, eliminating both of my parents. Do not lie. Do not talk about it with anyone. Ethics, 1,000% on my side. Plead self-defense. They're old. Just deny. Plead innocent. Will Americans give me grace, understanding? What about others that know my parents? They'd be mistaken to miss them. Go for a walk with my parents to a remote part of the farm where there are no visitors or nearby noteworthy events. Shoot them with my handgun or stab them, burn or bury the bodies. No cell phones or other electronics present to be used as evidence, cross-referencing. My necessary calculated risks have paid off tremendously. Trying to tamper with or dispose of some, possibly most or all of my parents' things will be a red flag. They just went out for a walk and didn't come back. Cause an accident? Plausible. I don't want to go to prison for life. Minutes, hours, and days after the act are essential. Will others start asking questions? I have a clean record. End quote. From another portion of the journal, Erik writes, quote, inherit my parents' things? All right. End quote. He continues, quote, call to report my parents missing, take off to another state, turn off phone and don't accept visitors/questions from relatives/neighbors. These people were silent/complicit in my lifelong misery/mistreatment, end quote. He later writes, quote, all I want is to get a bit of their property and not go to prison, end quote. Finally, this journal entry, quote, move out, visit them, go for a walk, do it, clean up, leave. Wait until people start asking questions. Act surprised. Flee, lay low for a few months in California. Say I wasn't close to them. Much crime, even murder, goes unsolved. Look at how long I've been selling drugs. How can I make it look like an accident? What about manslaughter? I want to do it very badly. I deserve to. When should I do it? Dead summer? Fall? Winter? Sooner the better. A time when my parents won't be expected to be anywhere. Do I need to do this? Move to Kimberly and see how things go. But then I shouldn't cut off all contact. Swear may be more isolated. Kill dad, then mom, could stab. End quote. In addition to these frightening journal entries, Mr. Metzig also provided an account of the murders to Dr. Lundbaum, stating, quote, I walked upstairs, then out to the garage and grabbed my gun. I headed back inside and crossed the house to my parents' bedroom. I walked in. I saw my dad laying in a bed. A voice shouted, kill him. I shot him until he was dead. I turned and saw my mom by the bed. A voice shouted, kill her, and I shot her. End quote. Mr. Metzig told the PSI writer that after he killed his parents, he cleaned the scene, dialed 911, and fled with the family dog to the YMCA in Kimberly. As the court can see, this was a planned event, as opposed to a heat-of-the-moment situation. David died from 6 gunshot wounds to his head, torso, and hand. Jan died from 3 gunshot wounds to her head and her hands. Over the course of these proceedings, Mr. Metzig has shown a willingness to try to manipulate the situation to his benefit. He initially pleaded not guilty by reason of mental illness or defect, a plea which was not supported by either doctor who examined him. One of the doctors explained the likelihood of Erik malingering, or in other words, faking mental illness. The evidence showed that Erik believed that if he was found in GI, he would still be entitled to his inheritance. After the NGI evaluators refused to support that plea, Erik entered his plea of no contest in August of 2024. His explanation of why he committed these crimes then changed from the voices told him to do it to blaming his antidepressant medication and jet lag, as outlined in the PSI on pages 5 and 24. He later began making claims that his father had abused him and his mother had allowed that to happen in an effort to withdraw his plea. As was discussed at the motion hearing, Mr. Metzig had manufactured that claim after seeing the news about the Menendez brothers homicide case back in October 2024. As a result of this history of manipulation, the state would caution this court to treat any statements of remorse from this defendant as yet another instance of Mr. Metzig saying things to benefit Mr. Metzig. All of this to say is that eligibility for extended supervision at any point prior to 50 years confinement is not appropriate. This is an individual who killed his parents in cold blood, motivated by a desire to inherit their property or money. This is especially aggravating because Mr. Metzig was, at the time, being supported by those same parents. They allowed him to live at their house. They gave him a job at the cheese factory. They supported him just like any parents would support their own child. I encourage the court to review and consider the victim impact statements and letters from community members. They paint a picture that I cannot convey. I did not know David and Jan, although from what I hear, they were wonderful people and even better parents and grandparents. The surviving victims, David and Jan's children and their spouses, have been through hell. First losing their parents to a horrifically violent attack by their own brother, and then to hear their brother try to ruin their parents' reputations in an effort to get a benefit for himself. Unfortunately, this court does not have the power to undo what Erik Metzig did in March of 2023. The state believes that justice requires life imprisonment with the eligibility for extended supervision at 50 years of confinement. The state asks this court to follow the recommendation. Thank you.
Are any of the victims' family members wishing to make a statement today?
My name is Metzig, and I am Dave and Jan's second son. End of January 2023, just 7 weeks before my parents were murdered, I experienced serious medical issues. When my parents learned about me being admitted to the hospital, they drove there immediately, even though knew I was sedated and had no recollection of their visit. When I was transported to another hospital, 90 minutes away, they arrived from that next hospital even before that ambulance, and would not leave until they were able to see me. Over the next 5 weeks, on a nearly daily basis, they would drive an hour and a half for the smallest of them, and just to be at my side. Throughout this time, I'm positive I was constantly in my parents' thoughts and prayers. They were there for me throughout my medical issues and throughout my entire life. They were there for all of us, including Erik. I may have been their son, but they would have shown the same compassion and love for him. It is unimaginable to think anyone could harm them, let alone their own son. If Erik is willing to murder our own parents and attempt to tarnish our father's reputation, the very people who cared for him and loved him the most, he is capable of harming anyone. We are fortunate to avoid a painful trial, but this means Erik does not have to be confronted with his horrific actions, nor does he have to admit guilt. 50 years from now, I will likely be passed away, but the next generation of our family will still be here. They may be the only people Erik knows. The family land and business may be the only location Erik knows. For justice for our parents and the safety of our family, please consider a life sentence without parole. My parents spent the last weeks of their lives worrying about my life, when I should have been worrying about their lives. David and Jan's endless generosity, support, and compassion will forever be missed and not forgotten.
Thank you, sir.
Hello, I am Metzig. I'm David and Jan's third son. As you can imagine, this crime has impacted us in so many ways. Not only are we impacted as the children of Jan and Dave, but we are also the brother of the assailant. We loved our parents and are very proud of the role models that they were for us. At the same time, we are devastated that this crime was committed by our brother. As you have heard and read through other victim impact statements, my parents were great people. I think one way to demonstrate this is through understanding what happened on the day before their death. They lived their last day like they lived their entire lives, prioritizing spending time with family and friends. My parents returned from a 2-week trip to Israel on Thursday evening. On Friday morning, my dad drove to Cedarburg to attend Grandparents' Day for our 4 children at their school. He was jet-lagged and behind on work, but he made this a priority to be at the school by 8 a.m. My mom was also planning on attending, but our brother Lou, as you've heard, was recently released from the hospital after heart surgery and needed a ride to the doctor for a follow-up appointment. They both returned home that afternoon, and then that evening they went to their friends for dinner. That would be the last interaction any of us would have with them. Early the next following morning, Erik did the unthinkable and killed the two of them. The police believed they were awakened and shot while in their bedroom. While this is tragic in so many ways, we will not let this act alone define who they were and the great life that they lived. They were the parents of 5 children, grandparents to 7 grandchildren, the 8th on the way. They ran a small business with her brother John. They volunteered at their church, and my mom ran several Bible studies. They were generous with their time and money, and they loved hosting their friends and family at their house. In the last 2.5 years, their loss has been felt in so many ways. There are no more holidays with my parents. There are no more nights at the grandparents with my children. There are no more deer hunting stories with my dad, and there are no more late night conversations with my mom. We've also missed them at graduations and baptisms during the same time. This list goes on, but the loss is felt every day. Unfortunately for Erik, this will define who he is and how he will be remembered. Out of justice for my parents, I asked for the court for a sentence of life without parole. I believe that due to the cruelty and severity of the crime, the premeditation and the lack of remorse, that a life sentence is only just. While we are thankful we do not have to relive this horror through an unnecessary trial, it does seem to lessen how terrible of an act it was. He planned this terrible act, attempted to conceal it, and denied responsibility until the evidence against him was overwhelming. Only then did he enter a no contest plea to avoid a trial. After he entered his plea, he then tried withdrawing it by making one of the worst accusations, that he was sexually abused by my father and it was covered up by my mother. Not only did he kill his own parents, but he then falsely accuses them of a terrible crime. Through this process, he delayed his sentencing by a full year. This delay has continued to bring heartache and grief on the entire family. It further demonstrates how evil Erik is and his complete lack of understanding of how terrible the crimes that he has committed. Even after 2.5 years in the jail, he has not expressed any remorse for his crimes. He has not apologized to the family, he has not taken ownership of his actions, and he certainly has not demonstrated that he is on a path to rehabilitation. If he had taken the life of just one of our parents, I would still be asking for life without parole. But the fact that he took both of their lives, I unquestionably believe this warrants a life without parole sentencing. We will forever have a hole in our life by the senseless act. However, we know that true happiness and joy are not found on earth, but through Jesus in heaven. We take great comfort in knowing that our parents were devout Christians and that we will see them one day in heaven. I pray the same for Erik.
Are there any further members of the victim's family that wish to make statements today? Seeing and hearing none, Attorney Schenk, go ahead.
Thank you. So sentencing arguments in cases like this are unbelievably difficult. And the reason why I say that is because the foundational thing that we have to look at here today, and that everybody in this room is looking at, is the tragedy of this event and how it's affected the family, all members of the family. And as we move forward in talking about our sentencing recommendation here today, my client wanted to make sure that everybody in the courtroom realizes that our job here today, at this stage, is to advocate for him, to advocate for what would be a proper sentence according to his interests. He's also aware of the fact that the one question that everybody will ask in terms of anything that we say here today is going to be, but what about his parents? What about his parents that don't have the same options that you're asking for here today? What about his parents that don't get the opportunity to live out their lives? What about the parents that are going to miss out on all their moments with their family moving forward? I want everybody to know that we're cognizant of that. And that's something that we have not forgotten. It's something that we're not discounting at all. But again, my job here today is to advocate for my client and advocate for his interests. So believe me, we are aware of the overwhelming tragedy that has affected the family, and that's in the back of everybody's minds. So the real question here today is, how do we adequately punish somebody for taking 2 lives in the manner in which he took them. Now, for a lot of people in the courtroom here today, and we've heard from a couple, and for a lot of people in the public and a lot of people in general, there is not a punishment that is enough for my client. Nothing we can do here today can adequately punish him. How do you put a number on a punishment for this kind of crime? It's hard to do. It's very difficult to do because nothing that we do here today is going to seem like enough. But here, in the presence of the law, according to the state legislature, there are things that we can do that are short of warehousing him for the rest of his life. And that's going to be what we're arguing for here today. And I'll explain why. And why is the key word here. That's the main question I think everybody wants to know. What caused him to do this? What makes somebody go to these extremes to take the lives of his own parents? What pushes somebody to something like this? The answer is complicated, but it's also simple. Mental illness is a big factor here. And I would submit that a crime of this nature very rarely happens without the presence of mental illness. One of the things that was talked about in the state's recommendation is that, my client was not found not guilty by reason of mental disease or defect. And I would submit that that is a completely different standard than having mental illness altogether. Not guilty by reason of mental disease or defect means that he couldn't understand the difference between right and wrong at the time. Quite clearly he did. We could see the journal entries, we could see the aftermath, we could see the items that he talked about when he was speaking with the psychiatrist, and it's clear that he understood the difference. But the mental illness that he was suffering from certainly led to the decisions that were being made. When you look at the PSI and you look at some of the things that he was talking about how a spiritual force was guiding him to do this, about voices that he heard, and items of that particular nature. And those things, and we've seen it many times in the criminal justice system, those things exist. They're real. Mental illness is not a fabricated situation. It's there. And I think it's somewhat corroborated by some of the items that were talked about by his family in the pre-sentence investigation report. I believe it was one sibling who had said, when I heard about what happened to my parents, I thought to myself, there's no way that it can't be Erik. The signs were there moving forward. His erratic behavior when it came to firearms, the way that he would talk about current events, the way that he would react harshly to things that nobody would react harshly to in a normal situation. The downhill spiral was happening, and it was happening before everybody's eyes. And we talked about how he has no criminal records, so there was nothing to establish that, perhaps that was something he was moving towards. He had a remarkable academic history in terms of being in high school and going to college and getting a degree. Mr. Metzig, Erik Metzig, is not the kind of person that we typically see in situations like this. So I would submit to the court that mental illness has to be the explanation for what happened in this whole situation. And his admissions and his behavior, they lend to that conclusion. Judge, even after the fact, some of the things that happened would suggest that mental illness was a large part of this. We look at the journal entries. For somebody that had truly premeditated what was going to happen and wanted to act on it, surely that journal would have not been left in the moment. That's something that obviously was not thought of at that point in time, something that anybody who would, with the most evil intentions, would think of to hide, didn't get hidden. We think about the way that he went to the YMCA afterwards with the family dog, and he had been reported soon afterwards because he was kind of a suspicious individual in the YMCA. That doesn't happen typically in situations like this. He was arrested without incident. These are things that we don't typically see in situations like this where there is a true premeditation to the murder. So, could anybody have done anything to prevent this? And I want to be sure to let everybody know, on behalf of my client, I don't know that there is anything in hindsight that could have helped him other than perhaps a different set of education, a different set of therapy. Not blaming anybody, he's taking the blame for what happened. But it's important to know that if anybody is thinking about what I have done to make this better, I don't know that there's anything that anybody could have. What we do know is that he was on the wrong medication at the time. And that has since changed in the last 2.5 years. And I think I have somewhat of a unique perspective to talk about that because I came into this case late. And the Erik Metzig that I have got to know here in the last few months is certainly not the person that I read about in terms of what happened. The Erik Metzig that I get to talk to is very cognizant of what happened, is very remorseful what happened, is very able to explain to me his feelings in regards to the entire situation. And it's not uncommon for me to see the best of somebody instead of the worst. But I can tell you that, you know, the idea that Erik Metzig is this ultimately evil person that is capable of nothing but evil is not the person that I see. I see somebody who now, properly medicated and properly counseled, is completely different from the person that we read about. I can tell you that he has a strong understanding of what happened, and he has a strong realization of what could happen here today. And he's concerned about it, but he's not so much concerned about himself here moving forward. He understands that the penalties, no matter what they are here today, are going to be severe. Contrary to what might be said by what we've heard here so far today, he does have feelings of remorse for his family and how this has affected them. And who, for the most part, from what I can tell in the PSI, although they want to see justice and they want to see the rest of the family be safe, they still have a strong sense of brotherhood and family bond with Mr. Metzig. And I think that speaks well to the family. They were obviously all well raised. There's no doubt that Dave and Jan were incredible people, and that's what we've heard about here today. I think their upbringing of everybody is on display. My client has talked about what it would be like to relive this day and go back in time, and obviously, in the state that he's in right now, he would love to change everything, and he wishes he had the opportunity to do that. So with all of those things in mind, the question then becomes, how do we properly punish somebody for these particular crimes? And there's really 3 different recommendations that are being recommended here today. And I'll start with what's being recommended by the family members and what's being recommended by the PSI writer, and that's to put him in prison for life without parole. And I think the general public and a lot of the victim's family would prefer that option. And I would submit that that's the easy option. It would take very little thought, empathy, or effort to warehouse him for the rest of his life. And I can understand that. And I think everybody in this room could understand that. My client understands that. However, under the circumstances that I've just talked about, I think there are other ways to do this. And I'm going to talk about those. First of all, the state is recommending that he be released to extended supervision after 50 years of initial confinement. Again, that's completely understandable. It's short of a life sentence, but it's essentially life. It's about the quality of life. He's going to be released to supervision as an old man with no real idea of how to function in the real world. And most of us will probably be gone at that time. But he's going to exit the prison with no support network and no viable means to support himself. And if you look at the way that the world has evolved in the last 25 years, we're in a completely different world today than we were in the year 2000. In the year 2075, it's likely to be something we can't even fathom. And Erik will be unequipped to handle that. So if we give him that punishment, it's not anything to sneeze at. It's not anything to consider light. 50 years of somebody's life is a long time. Our recommendation here today, Your Honor, is for 20 to 25 years of initial confinement. And to those that don't want him to see the light of day ever again, that could come across as a shocking recommendation. However, let me share just a couple of reasons why a 20 to 25-year prison sentence is nothing to consider light. When he gets out of prison under that particular recommendation, he's going to be a middle-aged man, past the point where he could build any sort of significant career. With his background, he's not going to be able to do that. He can't have any sort of long-term relationship with anybody. He can't probably won't be able to have any children at that point or have any sort of connection to the youthful years of his life. And again, I'm pointing out here, we understand that that argument flies in the face of the idea that his parents don't get to experience life anymore, and we understand that. But taking away those years of his life and putting him, and we got to keep this in mind too, putting him in an institutionalized setting where he's going to be able to seek rehabilitation of his mental state and the items that led to this is an important factor to consider. To be able to do that for a period of 2 to 2.5 decades is certainly, we would hope that that would be a long time to try to repair the situations that led to all this. And then when he gets out of the prison system, he'll obviously be on extended supervision for the rest of his life. But at least at that point, he'll have an opportunity to seek some sort of work, social connections, and prepare himself for his later years. So given our legal analysis here today, Your Honor, we have to consider a few different things, as we know, according to the factors laid out by the law. We have to consider, first of all, the character of the offender. And frankly, it's difficult to talk about because when you've been convicted twice of the most serious crime that we have on our books here in the state of Wisconsin, it does not speak well to his character. Everybody's aware of that. However, I think character goes beyond defensive actions. I think character has to do with a lot of different things, including the potential to live a better life and to be a better person. The depravity that exists now that may not exist in the future. And the remorse that even though folks don't think he has remorse, that he actually has, and will probably develop even more moving forward for the rest of his life. We can't undo what's been done, but we can think of what's going to happen in the future. We also have to think about protection of the public. After a significant period of time in prison and under the proper rehabilitation avenues, I don't believe that the public would be in danger from Erik. One could make the argument that the public in general was not in danger from Erik. It was a specific two people that were in danger. This particular incident was targeted at his parents, and for whatever reason, he never showed any signs of really hurting anybody before, hurting anybody afterwards. And after it happened, he was not combative or dangerous to anybody. His demeanor, at least the demeanor that I've gotten to know about Erik, is somewhat meek. With the proper treatment, I think he could be in a position where he would pose no threat to the public moving forward. And most importantly, Judge, obviously we're looking at not depreciating the seriousness of the offense. Again, it's the most serious offense, 2 of them, and that's understood. So how do we not depreciate its seriousness? And again, I think it's easy to lock him up for life without parole. That would not depreciate the seriousness of the offense because that is the most serious punishment that we can give him. However, as I've explained, these lesser recommendations that are being made here would give him an opportunity to respect the seriousness of that offense while still giving the chance for him to live some sort of life, albeit at a very advanced stage when he gets out. I think that ultimately the challenge for us here today is to somehow look 25 years into the future and envision Erik Metzig and where he is, what he's doing. Someone that has spent the youth years of his life incarcerated and getting help for the mental health issues that contributes to this and to the death of his parents. What does Erik Metzig 25 years from now look like? Could that be a person that could be released to society with a clear mental state and a strong realization of what he has done and what he needs to keep himself mentally fit? Perhaps. If we can envision that person in our minds, the question then becomes, do we want to be a part of his rehabilitated self? Or do we want to be a part of ignoring that rehabilitated self? Do we want to be a part of recognizing the solved problem? Or do we want to be a part of exacerbating that problem? Not right now, but again, 20 to 25 years from now, I think we ought to hold out the possibility of the repair of Erik's mental state. Another challenge we have to think about is, and I know it's difficult to think about or talk about, but Erik's parents are no longer here. Their lives have been taken by my client. One thing to think about is, if they had input on this, what would they want? And I don't know what they would want. I don't know that. I think those that know them might we can't guess at that. The only thing that we can do is, as best we can, put ourselves in those shoes. And again, as parents, I don't know what we would say in that regard, but perhaps those of us that know what we know about David Jan could make that conclusion on our own. So today, we could effectively end the quality of Erik's life, and everybody would understand why. His life on the outside. It's not anything we can do here today that compares to the taking of the lives of David and Janet. And we can strip the quality of Erik's life for good. And again, I think that's the easy thing to do, but honestly, Judge, I think we can do better. Not just for him, but for everybody involved. So I ask the court to consider the recommendation of 20 to 25 years of initial confinement with life on extended supervision afterwards. Thank you.
Mr. Metzig, are there any statements you wish to make today?
Oh, thank you, Your Honor. There is so much to say after 2.5 years of this whole excruciating process for everyone involved. It might be better for someone in my position just at a time like this just to shut up and say nothing, but there is so much for me to say, and it's really appreciated that I finally have that chance. I can talk about what happened, why it happened, what I was thinking, what was influencing me. I can address, I have deeply read and considered all of the victim impact statements and the pre-sentence investigation. I can address almost every sentence of both of those. And it's tough to know even where to start, but my parents were making me mentally ill, and I had sought out help specifically with them both immediately and sometime prior to the offense. So, for example, when I was immediately prior to the offense, I was on a trip with my parents in Israel. I had sought out emergency contact services about my parents because I was concerned about them. I literally reached out to the emergency services and said, I'm very, very concerned about my parents. There's something, I really need help with them. I tried to keep as much distance from them as possible. A year prior to the offense, I had reached out to a family friend and expressed to him how unsafe and how concerned I was about my parents for my own safety. I asked him if I could move in with them. When I had been seeing my clinical psychologist, we had had discussions, and he had pointed out to me how my parents were causing me to be depressed, causing me to be mentally ill. And that is something that, at the time that the offense occurred, I was severely mentally ill. I was mentally ill to the point of hearing voices. And I think anyone who has seen me, the discovery, has read related materials, has noticed my behavior, would obviously include that. And when you are mentally ill, it's very, what is or is not a reasonable action changes dramatically. If you can't, despite your efforts, if you can't live on your own or hold down a job or safely live on your own, then the options of what is a reasonable action for an individual, the calculus changes. And I was suffering the malign influence of prescription medication that I did not want to take. Due to the antidepressant medication I was given, I was more irritable and aggressive than I've ever been. And that was something that I was not even aware of at the time. I was not consciously aware of that. It was after I was speaking with my attorney, Stephen, he said, anyway, that was a medication that I'm certain that if I had not been taking that, this never would have happened. And that was a medication that I did not want to take, that I'm not going to throw, but a doctor recommended that I take that, and I knew at the time it was a bad idea, but I still took that. And there was a huge and growing scientific literature about the link between antidepressant medication and active, or I can't say the word, but irritability aggression, outbreaks of violence. So I had sought out, I was genuinely concerned about my parents. I had sought out help about them both immediately and sometime prior to the offense. I called the police on myself, frankly, the allegation that this was motivated by greed or money, just think about how would that work out. I don't even know. I know the prosecutor's job is to say the worst things imaginable, but it just, something like that makes me less safe. It further harms relationships with the family. And ironically, the referencing the Menendez brothers case, well, the prosecutor actually followed the script of that case, first saying, well, no, this is motivated by greed or money, which is not. I won't even do this. But I've read, and again, maybe it's better for me to not say anything, but I've read the pre-sentence investigation. I could respond directly to that woman's recommendation. Her recommendation, first of all, that woman failed to understand that there are multiple motives for sentencing. There's punishment, there's deterrence, there's containment, rehabilitation. That woman didn't seem to comprehend that there could be more than one purpose for a sentence, and her recommendation was just based on, she said the impact on the family and the community is immense. Just neglecting that there are, again, other things to consider with the sentence. The pre-sentence investigation, she said that my odds of having a support network are low, which 20, 25 years from now, none of us know what the world's going to be like. For her to try to make some sort of prediction about that is just really sticking her neck out there, I think, to say the least. Again, I've read and take the time to think about all the victim impact statements, and I can't speak to all of them. I can tell you for sure, at least some of the victims, things that they claim simply aren't true. One of the victims, she said she was so traumatized that when I went looking, they didn't know who I was going looking for next, which did not ever happen. You know how after the offense happened, I got with the dog and I drove to the YMCA. I was not looking for anyone else. I was not out for anyone else. The idea that I need to be, that I pose a threat to someone's children is very silly, in my opinion. Another one of the victims, she references an event where, and this is just, one of the victims, she thinks that I have some sort of, she's worried I'm going to commit hate crime against Jews. I promise in my life I've never spent any time. It's very silly. It's unfortunate that someone's wasting our time with that. And also, let's see. I was mentally ill to the point of hearing voices. Attorney Stephen was genuinely convinced that this would be an NGI plea. Was not wasting people's time by, it was a perfectly valid thing to consider doing as a defendant to pursue that. What else? And this has obviously been an excruciating experience for the whole family, unfortunately, and but I guess that's I didn't, all the material, I could have chosen to dispose of all the material. I basically, I didn't do a very didn't really make much of an effort to cover my tracks, and I called the police on myself. And obviously that, I mean, from a legal standpoint, that was very self-destructive. I mean, it's not, I think it's easy to see this, that my behavior at the very least was highly contradictory, self-contradictory. So to try and nail down, to make some ultimate value judgment about me as a person based on that is just, when you actually see the contradictory nature of it, I guess that's most of what I have to say. I'm also I'm very new to the criminal justice system. I've had perfect behavior in jail, probably one of the best behaved inmates in the jail, which even that is, you know, these last 2.5 years, I've been surrounded by more violence in these last 2.5 years than I have my entire life. So, I mean, really open my eyes. It really is unfortunate to be in that, be in that situation for anybody. I have no prior criminal record, and I have some speeding tickets. I am well educated. I have plans for what I would do practically with a life if I were given a chance for police to extend supervision. It would probably involve moving somewhere far away. So maybe everyone would be happy with that. Okay, that's it.
This matter comes for sentencing today with the defendant having been convicted of 2 counts of first-degree intentional homicide. A no contest plea was entered and he was found guilty of both counts. The maximum penalty for each of these offenses is life imprisonment with no possibility of parole or extended supervision. The minimum is 20 years of incarceration, followed by a possibility of extended supervision after that. Here the PSI writer is recommending life in prison with no possibility of parole. The state is recommending life in prison with a possibility of parole after 50 years. Defense is recommending 20 to 25 years of incarceration with life on extended supervision. The court has considered the arguments of counsel. I've heard today from Lewis as well as Metzig. Reviewed letters, one from the defendant as document 98. There were several family and friends that wrote letters as documents 99, 101, 102, 103, 142, and 144. I've reviewed the pre-sentence investigation, which is document 97. The facts of this case are rather straightforward. David and Jan Metzig shared a home with their youngest son, Erik. During the early morning hours of March 18th of 2023, there was a 911 call with a hang-up. Deputies arrived at the scene along with one of the family members. They found David and Jan deceased in their bed with multiple gunshot wounds. A short time later, the defendant was found at the Kimberly YMCA. During the course of the investigation, a notebook was discovered with handwritten information written by the defendant about plans to kill his parents. There were several statements in there, such as plead self-defense, cause an accident, kill dad, then mom, flee to another state. All clearly show signs of intent. In considering what is the appropriate sentence, there are several objectives that come into play in this case. One being protection of the community. Certainly when one commits such heinous crimes, the community needs to be protected. The court must also consider the punishment of the defendant, here this being the most serious of offenses within our community. There's no real possibility for victim restitution here. There was a victim restitution request on file from the estate, and we can address that at a different time. The court must also look at several things, one being the past criminal offenses of the defendant. Here there was not really much other than some traffic citations. The court also needs to look at the history of an undesirable behavioral pattern. Here there was some slightly odd behavior that had begun occurring by the defendant, but it was not necessarily undesirable. The court must consider the personality, character, or social traits of the defendant. Here the defendant was somewhat reclusive. His behavior was getting stranger in the days and months leading up to the crimes. The court must consider the viciousness or aggravated nature of the crime. Here it was extremely vicious. It was attacking victims while they slept in their beds in a most vulnerable state. The court must also consider the degree of the defendant's culpability. Here there is very little culpability. There's some victim blaming, some medication blaming, but very little remorse is being shown. The court must also consider the age and health of the defendant. Here he's 28 years old and in relatively good health. His education is college educated. Employment history is somewhat difficulty holding down a job. The rights of the public as well as the family need to be considered here, and they certainly have been through great difficulty over the past several years. That being the family has been through what no family would ever want to endure. That is the greatest importance, is protecting the public as well as the family in this particular instance. The court weighs heavily the opinions of the family members in this case. All things being considered, Mr. Metzig, you are hereby sentenced to life in the Wisconsin State Prison System as to count 1 with no possibility of parole. It will be the same sentence as to count 2, and both sentences will be consecutive to each other. There is no eligibility for the substance abuse program or the challenge incarceration program. Because of this conviction, you may not vote, and it is unlawful for you to possess a firearm or body armor. You do have the right to seek post-conviction relief. A notice of intent will need to be filed within 20 days. You also need to pay all court costs associated with this case. As to the restitution request,
The defendants have filed a restitution request to cover relief, some attorney's costs and funeral costs, so after we work with that, if the defense stipulates.
is the restitution being objected to?
No challenge to the restitution.
So the restitution request in document 143 will be ordered as well. Is there pre-sentence credit amount that needs to be?
944 days.
So that will be reflected on the judgment of conviction as well. Is there anything further from the state?
No, thank you.
Anything further from defense?
No, thank you.
And we are concluded on that matter.